Okay guys, I want you to imagine for a second that you're an employee in Ontario that was fired for cause due to poor performance. And as a result of that, you decide to sue your boss for wrongful dismissal. You don't agree. You think that while you weren't a perfect employee, it wasn't enough to amount to cause for dismissal and that you're still entitled to notice. So the employer refuses to settle the case. There's a trial date set. And 2 weeks before the trial date, there's evidence that comes out to suggest that you stole money from the cash register. Now the question for this video is, can the employer rely on evidence of employee misconduct that was learned after the decision to terminate the employee? Now, for those of you watching this, you might be wondering, why should I care? Well, the reason why you should care is because the more evidence to support employee misconduct, the stronger the potential case for cause for dismissal. In other words, just because you had poor performance, maybe that alone wouldn't have been enough to amount to cause for dismissal. And you might indeed have a case, not legal advice, just legal information, but you may have a case for wrongful dismissal because of that, because it doesn't meet the threshold of cause for dismissal. However, if the employer is allowed to rely on that misconduct, especially if it's very severe, like theft of the employer, maybe that might change the outcome of the case. So, can they rely on it or not? And the courts have said that yes, the employer can rely on that, even though they didn't find out about that until after they terminated you. And they can actually change the reason why they terminated you to theft instead of poor performance. In fact, there's a leading case right here that by the Ontario Court of Appeal that describes the rule way back in 1889. And it says, it is now settled law that if a good cause of dismissal really existed, it is immaterial that at the time of dismissal, the master did not act or rely upon it, or even did not know of its existence, or that he acted upon some other cause in itself insufficient. The main question always is, were there at the time of dismissal facts sufficient in law to warrant it? Okay, you might be wondering, that's great, Andre, so what's the moral of the story here? Well, a few things. Number one, always be honest with your lawyer. If something happened at your workplace that you think, maybe you didn't do correctly, or whatever the case may be, you need to disclose that to your lawyer. That way we can assess the whole picture and tell you if you actually have a case for wrongful dismissal or not. Because if you're withholding a piece of information from us and it later comes out that just before trial this huge fact occurred and we planned our whole case based on something else, that could actually change the entire outcome of the case. So it's important to be honest and upfront with your lawyer and tell him or her exactly what happened, and so that we can, first of all, tell you if there's a case worth pursuing to begin with, and if there is, how exactly we can navigate the case based on those facts. As always, if you believe that you are wrongfully dismissed from your job, you're welcome to contact me or any other employment lawyer in Ontario. This has been Andre Issa, your friendly neighborhood employment lawyer. Until next time.